VP Pachudi and Premier Ramatuba. Welcome, and we do apologize for keeping you waiting all afternoon. We were supposed to interview your candidates much earlier, but it is the nature of the business of this body for things to delay, things come up unexpectedly. We've had a very busy day, but the delay is regrettable. And that the apology extends to you as well, Mr. Kholong. All right, are you ready?
Yes, Chief Justice, I'm ready, thank you.
Okay, let's do this. And time is okay. We interviewed you just last Friday, 10 October 2025. So we are not going to put you through the unnecessary pain of questions to which you already have the answers. We have a full transcript of your full interview in front of us. We know exactly who you are. So what we plan to do is to just give you an opportunity to explain the memorandum from you that we received this morning, raising certain issues pertaining to your interview last week. And then I will allow the commissioners to put questions to you, if any. Right.
Thank you very much, Chief Justice, for the opportunity, and I think thank you to the commissioners for the guidance that was given to me on the occasion of my previous interview.
Just pull the mic closer to you and try to speak louder.
Thank you. Arising from that experience, I deemed it prudent, honorable commissioners, to settle an explanatory memorandum to deal with matters that I believed were left hanging in the minds of commissioners, in spite of the concessions made during that interview. One of the key questions that arose was circumstances arising from my nomination and acceptance, the similarities from the two nominators, in spite of the fact that they were from different locations, as Honorable Commissioner Tlaleti then raised. It occurred to me, as I considered that the acoustics failed me a bit and I didn't quite get the question, which actually derailed my responses moving forward. So I deemed it prudent to settle a memorandum, firstly dealing with that confusion that may have arisen out of the similarities in the templates used by nominees and the acceptance letter. But also, just put it on record that with the indulgence of the JSC, I plead that reference to 2004 as then discussed should be understood to mean 2024, the finger error that was discussed. But I think also relevant to this interview, Chief Justice, Commissioners, I noticed that out of 3 bodies that had commented by the closing date, I had 2 positive comments from Advocates for Transformation and the Law Society. I had a negative comment from the Black Lawyers Association. As of the date of the interview, I had 4 positive comments and 1 comment that was not positive. And I thought that it behoves me to take the JSC into confidence in terms of my responses to that issue. The Honorable Minister had also raised an issue around accessing some of the work that I had dealt with, and I thought that for the convenience of the commissioners and the Honorable Minister could share one such. I noticed that there are three names that I work with, but the name that I'm most commonly known for is actually Shami, which is perhaps where the confusion might have arisen. A lot of the articles that I wrote were under Shami Kholong instead of Solomon or Tebo. So I thought that was the one issue that I needed to deal with. Chief Justice, I confirmed that I had a discussion with both Ms. Dlamini, my nominee, and Mr. Nguku, my second nominee, regarding my nomination. In respect of Mr. Nguku, who was interested in nominating me, our discussion started in 2004 and again around May 2024, I beg your pardon, and again around May 2025. In respect of Ms. Dlamini, we discussed the nomination in June 2025. In both respects, once I decided to accept the nomination and move ahead with it, I agreed with both Mr. Nguku and Ms. Dlamini that I'll provide them with a template document which they could use for the nomination, as all of us had no experience handling JSC nomination. That template document has been generated on my computer in previous years for nomination to other bodies. Both Ms. Dlamini as reflected in Exhibit A. And Exhibit A is an email, Honorable Commissioners, addressed to the Commission. And in it, Ms. Dlamini points out that I hereby confirm that all the information provided with regards to my nomination of Advocate Kholong JSC is true. A template document was shared with me in June, which I then considered and used for my nomination. Noted Ms. N. Dlamini. That's Exhibit A. And I also attached Mr. Nguku's copy of the nomination letter sent to me on 12 June 2025. That's Exhibit B. Now, in it, Honorable Commissioners will note that it was sent on the 12th of June 2025, and Mr. Nguku addresses it to both my emails and says, "Would they please find attached the signed JSC nomination for your attention? Kind regards, William." I had agreed with them that we will finalize the nominations on the 12th of June, which we duly did. That is the reason the letters are all dated the same and the nominations are the same. Ms. Dlamini was with me in Johannesburg and Mr. Nguku had been traveling outside Gauteng at the time. As agreed, all documents were put together for submission by me, together with the questionnaire and other required documents by JSC in June 2025. As stated previously, I regret the finger error on paragraph 9.2 and paragraph 8, which reference 2004 and 2024. I think that is a lesson in a learning that will, editorial error that will, last one a lifetime. I'm indebted to the commissioners for the guidance that was given to me in respect of that particular finger error that I had made. Addressing the concern by one of the law bodies about provincial experience, my submission to this august House is that despite having no adverse comments by 2 of the 3 law bodies as at the closing date and 4 of the 5 as the date of the interviews, a concern was expressed about my lack of experience with what it terms customary law cases in what is termed rural province like Limpopo. Honorable Commissioners, I respectfully submit the following in response. Firstly, besides the work that I did at the Limpopo provincial government over the years in their governance structures holding the legal portfolio with oversight over a number of departments, including the Premier's Office and COCTA, which departments are assigned to deal with, amongst others, issues of traditional leadership. I have, in addition, also extensively dealt with and served in the structures of different localities in Limpopo, like the Capricorn District Municipality, where the provincial seat is located, and Polokwane Local Municipality, Tsanin Local Municipality, Maruleng Local Municipality, Giani Local Municipality, Letaba Local Municipality, Mapalabora Local Municipality, and Elias Motswaledi Local Municipality, amongst others. Many of these localities and communities have a number of tribal authorities. I served in these communities, which also had many matters on the role of the provincial division, wherein I exercised oversight with dedication and skill that demonstrated experience, acknowledgement of this work in the communities. And I must pause here, Chief Justice, Honorable Commissioners, to say these communities are communities that are constitutionally recognized in terms of Section 152 of the Constitution. And my plea and submission to the Commission is that their observations must be measured against the criticism of the BLA, in addition to the positive comments, 4 positive comments that I've received from the law bodies. Honorable Commissioners will note in Exhibit C a certificate of appreciation, and it states, this is a certificate of appreciation for your years of dedicated and outstanding service as a member of the Audit and Performance Committee. And this certificate is signed by a constitutionally recognized structure representing the communities of Polokwane. That's Exhibit C. In Exhibit D, there's a certificate of recognition accorded to me for the work that I did between 2012 and 2016 for being a member of the Audit Committee at Akhanan Local Municipality. Now, there is no, I can't think, Honorable Commissioners, Chief Justice, of a more rural community like the community of Akhanan Local Municipality as it then was. And the duly recognized and elected representative of those communities with tribal councils deemed it fit, based on the work that I did in those communities, to accord me a certificate of recognition, holding the legal portfolio and exercising oversight and guidance on matters on the roll before the provincial division of the High Court in Limpopo. The same can be said of all these other local municipalities and district municipalities that I had the privilege of working with. So I put before you Exhibit C and Exhibit D in response to the criticism of the BLA. In terms of academic grounding, besides being steeped and fully understanding African customary practices as an African, I've also studied customary law as a discipline at the University of the Free State and African politics at Wits University. That gave me academic grounding and I believe would enable me to deal adequately and competently with any customary law matter that may arise should I get the nod of this commission to the division. I was further in the senior management at the then Department of Provincial and Local Government that processed the white paper on traditional leadership and resultant Framework Act. I beg your pardon. Traditional Leadership and Governance Framework Act. And I pause here to mention, Chief Justice, Honorable Commissioners, that this white paper and bill and consequent legislation was processed if honorable commissioners would note as per paragraph chronology of work done since leaving college, which is paragraph 6 of the questionnaire. I mentioned there that I was in the Department of Provincial and Local Government from 2002 to 2004, 2004 to 2007, holding the title Director and later Senior Manager in that department. So I was part of the senior management that processed the bill, the white paper in the first instance that deals with these issues of customary law, and later bill and act that deals with Traditional Leadership and Governance Framework Act. Even though I was not in the core team, I was part of the management that considered and helped shape both the bill and Traditional Leadership and Governance Framework bill before it went into cabinet and into parliament. So I'm fairly conversant with policy issues. I'm also fairly conversant with the legislative framework that deals with issues of customary law and practices. And I also pause here to mention that a lot of the disputes, by the way, in the provincial division, has to do with disputes about who, in most instances, is the most deserving or rightful appointee to the role of traditional leadership. Now, in spite of reference to customary practices, a lot of that and guidance in terms of how that is to be dealt with, whether in terms of ancillary legislation by the premier in the province, or in terms of the act, for example, for purposes of the king and queens, this particular piece of legislation, with which I interacted with as early as 2003, is the policy framework that guides issues of customary law and practices in the country. So on that basis alone, I respectfully submitted that that experience must be deemed to be sufficient experience that enables me to can deal with any customary law matter as may arise in the division should I be successful in this nomination. I've already, addressed the issue of articles which I also attached in Exhibit E, Chief Justice. I thank you, honorable members of the JSC.
Thank you, Mr. Kholong. All right, I'm going to hand over to the commissioners to put questions to you. None of us are bound to put questions, are bound to confine our questions to him, to the explanation is just given now, and that applies especially to the JP and Premier who have not interviewed him at all before. On that note, over to you, Premier.
Evening, I wanted to say morning. Evening, Chief Justice and evening.
I'm sorry, it's the JP. What did I say, Premier?
Yes.
The JP goes first. It's been a long session. Sorry, Premier.
Thank you very much, Chief Justice, and good evening to you and to the honorable commissioners. Good evening, Advocate Kholong.
Good evening, JP.
Yes. I will not be confining questions to this document that you have filed, but I would like just to shoot straight from the questionnaire that you have submitted timelessly within the time which we are required to make a submission. Having gone through your questionnaire, I've noted, and there's no doubt about it, that you have acted in both the the Western Cape and Gauteng divisions of the High Court as an acting judge. But however, you did not act. I do not see anywhere where it seems to me you have acted in Limpopo division of the High Court, both in Polokwane as well as Siwendu local division. Am I right?
Yes, Judge President.
I see. And the fact that you have mentioned in your in the document you have identified this explanatory memorandum explaining your exposition to the activities in the Department of Coxta, not Cocta, Limpopo, does not mean that you got any exposure in any of the traditional leadership disputes and claims that obtained in Limpopo province. Am I right?
The only way I interacted with that was through my holding portfolio legal in the provincial audit and governance risk committee, where matters in which both the premier and the local and Coxta are parties. We, as structures of the provincial government, we had a duty to exercise oversight and be able to guide, be it the DG or the head of department, with a view to advising, where appropriate, EXCO on efficient management and case management of those specific cases as and when they arose. So that is the experience that I had in respect of those matters.
Yeah, but that does not that's not applicable to litigation in that court. Is that my understanding correct?
No, we'll be getting reports from a client or whether the Premier's office or Coxta in individual case would be a respondent. It will be from that perspective that we'll be getting reports and we'll be giving guidance on the efficient management of those cases. Whether the opportunities for alternative dispute resolution, whether those cases should be left on the roll. So it will be from that perspective that we'll be dealing with those issues, JP.
Thank you. But however, the purpose of my question is to establish the extent of your familiarity with the applicable practice directives in those two courts. Strictly on litigation.
Yes, I've familiarized myself, but of course, nothing beats practical experience. But where I was coming from, JP, was that, the Constitution and the legislation requires a person with legal qualifications who's fit and proper for appointment. It was against that backdrop that, with experiences that I have of the province, that I thought it expedient that I can make a contribution in the manner I was nominated.
All right, let's leave it there and proceed to another question. You will note that the Limpopo division of the High Court has at the moment a composition of only 7 permanently appointed judges, of which only 3 are women or females. That is 2 Africans and 1 white female judge. Now, the current vacant post for which you have applied is also contested by a female aspirant judge who, if recommended for appointment, would balance the race and gender equation in our division. Now, the question is, would you have any objection if you could volunteer to step aside, tipping the scales as to give effect to the provisions of Section 174, sub 2 of the Constitution, that is for the judiciary to reflect broadly the racial and gender parity, especially for the Limpopo division of the High Court? Would you do that? Or consider to do that?
I support the principle of women empowerment, and I also support the good work which this commission and the Chief Justice has done for the empowerment of women in the country. I put forward the nomination, being mindful of the appointment in the previous year of a woman judge to increase the number of women from 2 to 3 in the province. It was against that backdrop that I thought it would have been fair and equitable to, in this instance, having appointed a woman in the previous occasion, to consider appointing a black male, a young black male in this current cycle.
Yes, but then doing so would now increase the number of males than to balance the equation with race and gender. Would you agree? Because we'll be having now a total of, say, 4, 5 male judges instead of having 4 with the new post we intend to create now. You see where I come from in terms of the imbalance, gender parity.
I understand that, but I was, and perhaps this is where my human resource or organizational development grounding comes in. I was looking at the Office of the Chief Justice as a whole in terms of gender, race, youth, balance, in terms of both divisions, but also the national picture, how it looks like.
All right, let's proceed to your permission, Chief Justice. Let's turn to page 17 of your questionnaire at paragraph 6.3. Have you arrived at that page? Thank you. You have enumerated 4 cases which you regard as most significant. However, you failed to make provision with regard, rather to properly give a citation for one to can track those cases. I mean, they're from 1, 2, 3, 4. The question there is which cases in which you have appeared would you regard as being the most significant and why? Now, I was unable to trace this, to track these cases because of improper citations. Perhaps can you assist us? Why is it like that?
My page 17 has paragraph 9.4 to 9.4, 9.5, 9.6, and paragraph 1, JP.
Yes, I refer to the cases at cited under paragraph 6.3 at page 17. Let me give you an example. This case, which number 2, Temba Velase versus the state. We don't know what the citation is. Number 3, Marman and 15 others versus Raf. Neither is there any citation proffered, given rather. Is there perhaps an explanation for the omission?
No, I had assumed because they were attached, they are part of the cases, JP, that I had attached. The Prudential Authorities case number 1, in terms of the order of cases that I had attached, it's in fact 6 different cases against the Road Accident Fund, where parties agreed for all the 16 cases to be heard. This was in the Eastern Circuit Local Division in Thembaletu. And that's Marman. The Prudential Authority is case number 1 in terms of the order of cases I had attached, and this is case number 2023-071935. In Gauteng division, JP.
All right. Now, turning to page 18 at paragraph 6.4. Required to list all the reported cases in which you appeared as an instructing attorney. And you state that I appeared as a corporate counsel in the following matters. There you listed 1, 2, 3, and 4. I took the liberty to go into, for example, the Constitutional Court case of Johnson Matotoba, Nokotiana, and others, and Ekurhuleni Metropolitan Municipality. Then, upon perusal of this case, I went to check as to who the instructing attorneys were. And with respect, I could not find your name as an instructing attorney in this matter, which is clearly reported as CCT 31 of 2009. Perhaps maybe it could have skipped my attention. Do you agree with me?
No, I'm with you, JP. In the previous occasion, I made a concession that perhaps I was over-eager because the question specifically requires instructing attorney.
Yes.
So I should not have tried to be creative to indicate the client role because I was corporate counsel in the client or party, that being Ekurhuleni because I was the corporate counsel of Ekurhuleni at the time. But I think I misdirected myself, filling the form in the manner in which I did because it requires an attorney, or at least I should have phrased what followed below much better, perhaps to read I was corporate counsel of one of the parties or a client in the following matters. It would have read better because I was corporate counsel and legal advisor in those institutions that gave instructions to the attorneys and counsels that dealt with those matters on our behalf, JP.
Yes, but then you did not address yourself to the question, as it appears in paragraph 6.4. It required of you to list reported cases. Now it is clear that the Johnson Matotoba case has been reported under CCT 31 of 2009. It's a constitutional court matter. Now, one would have expected if you appeared, as the question says there, as an instructing attorney, then your name would have appeared. But here it is recorded that counsel for the applicants were Advocate Mensing, instructed by Weber Wenzel, and then counsel for the first respondent is Advocate Campbell, SC, Advocate Creer, instructed by Bam and Yaya, and counsel for second respondent, counsel for the is Advocate Matlanga, SC, should I say SC then was, and Advocate Rajab Brundla, instructed by State Attorney, and there, counsel for the third and fourth respondents, Advocate Gilmarcus, SC, also instructed by the State Attorney. Nowhere is your name mentioned as an instructing attorney in this particular case. Do you agree with me?
Yes, no, I misdirected myself there.
Okay.
JP.
The same could be said of Matetiele Municipality and others. This is President of the Republic of South Africa. That's also a constitutional court case. But on going to Safli, your name as an instructing attorney is neither mentioned. You also agree?
Yes, I was a client. I was representing, I was an instructing client as Chief Legal Counsel of Ekurhuleni Metro in respect of Nokotiana, and I was Chief Legal Counsel of respondent Ekurhuleni Metro in terms of Nokotiana, and in respect of the Eden Park extension, I was the Chief Legal Counsel for Ekurhuleni Metro. And in Matatiele, this is the President and others. I got involved in that matter as a manager on behalf of the then Department of Provincial and Local Government.
Okay, that might be so, but the fact is, you have, to a reasonable reader, one would have expected you as an instructing attorney to have had your name enlisted in the latter matter that I've mentioned. Was that also an omission to say that you're an instructing attorney there?
And below that question, which is where my concession of misdirecting myself came in, I mentioned below that I was corporate counsel, and that is not what the question required as I was guided the last time I appeared.
All right. You will also assist me if you turn to page 10. Sorry to take you backwards. Page 10 of the questionnaire. You have mentioned that your membership of Mangaung Youth Congress and SAICO, having been a member from 1987 to 1988. Am I right?
Yes, JP.
Right. Immediately thereafter, also indicated a member of the ANC, 1991. But you did not disclose if you are currently still an ANC member or if your membership ceased, and if so, since when? Am I right?
Yes, JP, my membership of the ANC has expired. I was mindful of the fact that a judge, if so appointed, cannot be politically affiliated. So it expired a long while ago. Not only for that reason, but also because of my commitment to professionalization of the public service. So I know that a public official cannot be a member of a political party.
Yes. But what I'm saying is, why the difference? I mean, in the case of Mangaung Youth Congress, you've indicated the period when you became a member and when a membership came to an end. But however, in the case of ANC, it remains as 1991, and you haven't indicated whether membership has expired. So to me, it appears that you're still a member. Am I right? That's the interpretation one can accord there. And if so, what are you going to do in the event you are being considered for appointment as a judge?
I have not renewed my membership of the ANC Judge President for a while, mindful of the role that a judge others has to play in terms of being non-partisan in dealing with disputes in communities. So I can assure this august house that I'm not a member of any political party.
I see. Well, finally, or lastly, South Africa today faces great challenges of overcrowding at detention facilities. Are you aware of that? And this issue of overcrowding in this country, especially in Limpopo province, is a menace to the remand detainees awaiting trial. As a judge, or if appointed, what legal mechanisms, if any, would you employ in order to alleviate overpopulation at correctional services centers? Legal mechanisms.
I mean, as a judge, one would obviously have to apply themselves more in terms of, firstly, the requirements of Section 60 in terms of awaiting trial prisoners, but also on conviction and sentencing. One would have to, assess the gravity of the crimes that might have been committed, and whether it would be just an equitable, to commit an offender or not. So one would have to carefully weigh each individual case very carefully to ensure that only deserving offenders are committed.
Is that all? You wouldn't consider, or rather, if you're aware, the provisions of Section 62 sub A of the Criminal Procedure Act, 1977?
Yes, we'd have to, consider all the, relevant applicable provisions, JP, to ensure that, there is proper balance, between, in case of, people that have not been sentenced, that, you only commit, you only retain those that would not meet the bar in terms of either being able to demonstrate, exceptional circumstances in respect of very serious crimes, or that the interest of society warrants that such people be released. I think that balance, one would have to be mindful of it as and when one deals with these matters.
Well, Advocate Kholong, I thought you also enlarge so as to satisfy my question on the provisions, not only of Section 62A, but also traverse Section 62F and Section 63(1) of the criminal procedure. Those are the mechanisms which courts can employ in order to mitigate the problem of overcrowding our prisons. So, but I thank you very much. Chief Justice, I have no further questions.
Thank you, JP. Premier?
Good evening, Chief Justice, and evening to all the commissioners, and thank you for inviting us to this process. I think the JP has covered me, but evening Advocate Kholong.
Good evening, Premier.
Maybe just a follow-up from my interest as a Premier of the province on mainly on the issues of the Traditional and Khoisan Leadership Act of 2019. I've heard your presentation tonight, but I just wanted to understand, because you focus on your experience, which you explain as if it is a relevant experience, wherein you are focusing on being a audit committee member. If the mandate of the audit committee, you've gone through it clearly and see how does it link with this particular act, and how will it assist you, because the province is 80%, more than 80% rural, and the biggest headache is stability amongst the traditional councils, which has got impact on the economic growth, because investors do not want to invest in province where there is instability. Now, the internal or being a member of audit committee, which you cited and gave us the certificates of appreciations, when I go through it's mainly a focusing on the governance and performance, mainly on internal controls, reviewing the management strategies to make sure that the annual financial statements are done properly in terms of the law, and all the municipalities that you have served. I can tell you, even today, they are still outsourcing annual financial statements, meaning all those who served in those audit committee failed us as a province. That is just by the way, but I just want to understand, why would you bring this as evidence that you do have experience in terms of this particular act, which as a province we need a judge that is very clear in terms of practical experience and would help us to move the province forward.
No, thank you very much, Premier, for that question. My experience as we're engaging with key management, both at local government level in the various municipalities, but also with the provincial department of local government and that of the Premier, where we are, amongst others, dealing with issues that the Premier is alluding to, is the failure to ensure that, firstly, there's proper conclusion of partnerships between traditional councils and municipalities. Because for the province to be able to deliver, if you're talking about community-based planning and development, our advice to the structures was that there must be proper partnerships and even agreements that would, for example, dictate your integrated development planning processes, how the traditional leadership interchanges with those processes. But my experience, in spite of the advice and some of the reports that would give to the executive authorities, like councils and feedback which would be filtering through to EXCO, is that because of capacity challenges, a lot of that work was not moving with the speed which we desired. Our view, and my view on that question, Premier, is that the partnerships as constitutionally envisaged between traditional councils and the localities need to be practical and working so that, traditional leaders, sub-councils, councils can be able to meaningfully contribute to the development of the province. So that is one area of work that still needs to develop. It appears, that there's more of a ticking exercise when it comes to integrated development planning. When your IDP circles come, and at times you inquire as to the degree of interaction with traditional leaders, a lot of that interchange, very often we are not able to pick it up.
You see, the more you elaborate, the more you confuse me worse. Because in your just explanation now, if I was looking for the special advisor to the Premier on the issues of traditional affairs, you would be very relevant. But here we are looking for a judge. The judge which were in a province like Limpopo, which has got one queenship, which is currently under dispute and in front of the courts. Two kingship, the Bavenda and the Bapedi, they are equally in the courts. If you look at the senior traditional leaders, more than 800 cases amongst the Mahoshi, Manduna, they are within the courts. Now, the judge must be able to assist us on those. The advice you are giving us is what we need to do as the Premier's advisor or Coxstar or Premier herself. But here we are looking for somebody with the experience to can be able to assist us when it comes to those matters that are within the courts. So that's why I'm saying the more you talk, the more you confuse me worse.
No, thank you very much for that question, Premier. I think the key thing as a judge would be to assess whether processes in cases where such conflicts obtain in terms of African customary practices and as now envisaged in terms of the Framework Act have been followed, because and the provincial ancillary legislation, because those processes are defined in legislation in addition to customary law practices. So to the extent that exceptions might be identified, for me as a judge, if those processes have not been properly followed, either in terms of determination or otherwise of designating Mahoshi, would inform, one's decision on each one of those individual cases, Premier.
Thank you.
Thank you, Premier. JP Taletsi.
Thank you, Chief Justice. Good evening, Mr. Kholong. I propose that you keep your mic continuously on because my questions are going to be very short. Yes. Ms. Muniz, who nominated you for this position is the same one of the two who nominated you from Mpumalanga.
Yes.
Are the same letters identical? Is this letter identical to those two?
No, I understood your question last time to say why.
No, answer the one now. Is this letter identical to those two? We'll come to the explanation.
It's an email.
Your nomination letter that is written by Ms. Muniz, Dlamini. Is it the same? Yeah, Ms. N. Dlamini. Is this letter identical to the two in your nomination from Mpumalanga, Division of the High Court?
Commissioner, I understood the difficulty that we had being the similarities in font, in the dates, in spite of people being in different localities. So that was the specific question I was answering.
Yeah, but then answer this one now. Is it identical to those two? Is it anything other than that is for this division, Limpopo? Are they not the same or identical? Same similarities?
They would be the same.
Are they or not in the that they would be? Are they the same? So that I should understand.
I'm not certain of that question whether they're the same because one was addressed in respect of Mpumalanga, the other is addressed in terms of Limpopo. So they cannot be the same if one is addressed for Mpumalanga and the other is addressed for Limpopo, if I'm understanding the question correctly.
Yeah, I'm saying the difference will be the name of the court, but the contents are the same. They're identical.
Indeed.
Including the font, the number of words in the same letter.
Yes.
And then your letter accepting this nomination is also identical, except for the identification of the court to which you've made yourself available the same.
Yes, because we use the same template.
Yes, let's deal with the template. For the template, what did you send? What was contained in the template?
The template was the paragraphs as it was a template because they've never what do you call it? They've never made a nomination as we discussed, the matter with them to the JSC. So they asked me, how does the nomination be looking like? It was on that basis, based on my experience with previous boards and entities that I had worked with, that I agreed to share with them a template they could look at in considering the nomination.
What was contained in the template?
It was nomination to the provincial divisions, as you have it before you, Honorable Commissioner.
The information in the letter, is it what was contained entirely in the template?
Yes.
So it's difficult to say everything that is in the letter is what you sent to them.
I can't speak to that right now, but it was more or less the same. I mean, when it came back to me, it looked more or less in the same mold as the template that, that I had sent to them.
So what they say about you is what you told them to say about you.
No, I shared with them information about myself, including qualifications and experience, which they did not know. I did not tell them what to say about me. I provided them with a template.
Yeah, but you said the template was the same. So what is contained in the nomination and motivation letter is what you shared with them, and it came exactly as it is.
It would appear they were happy with the template that I had shared with them.
Yeah, well, happy or angry, I'm not saying it came the same. So actually the views expressed are your views and not theirs.
No, once they, determine that that is the template that they're going to use, as Ms. Lamini states, and as illustrated in the email that has been shared by Mr. Nuku, that is the nomination that they used. So they were not expressing my view or anybody else's view. That would be my respectful, submission. I just provided them with a template.
Okay. Just help me. Previously in your interview, you said you gave them nothing. They drafted the letters.
No, I said exactly the same thing. And that is what I thought when I said my answer could have been better. Because I said I provided them with information and I ensured that the quality of that information would be the correct one for submission to the JSC. And that was the answer that caused, a bit of a discussion by the JSC the last time.
You said you gave them, you did not, they are the ones who drafted the letters. That was the first version. Later you said you shared information. Today is the third version. You say you shared the template.
Well, template and information is the same thing with respect, Honorable Commissioner. And if you, as you can see on exhibit B, titled Nominations JSC. Good day, please find attached the signed JSC nomination for your attention. Kind regards, William Nuku. So it is Mr. Nuku making the nomination and not myself.
Yeah, she only signed. She says so, doesn't she? Please find the signed, meaning she received something, she was merely to sign and send it back to you.
If you go to, Exhibit A, addressed to the Secretariat of the Judicial Service Commission, Honorable Commissioner, it says, I hereby confirm that all the information provided with regards to my nomination, of Advocate Kholong to the Judicial Service Commission is true. A template document was shared with me, so it's not me saying that. There's an email that is addressed by Ms. Lamene to the Judicial Service Commission. A template document was shared with me in June, which I then considered and used for my nomination.
Yeah, I'm just concerned you are making it worse and involving other people with these letters. But then if we take the matter further, don't you think it would have been advisable rather to take some time and get everything in order so that when you appear before this commission, you don't have to deal with these aspects? You were requested, I think, by Councillor Pile to say, reflect whether you still want to come and appear having had this kind of an experience in that particular interview.
Yes, but what the commission has in front of it is confirmation of the nomination, Honorable Commissioner. It's not myself. It's not myself making the nomination. The email that is sent on the 13th of October by Ms. Lamini makes it clear that she's the one who made the nomination. The copy of the email sent by Mr. Nguku on the 12th of June at 13:09 makes it clear that he's the one making the nomination.
So you stand by this nomination. So I can argue, am I free to say if you lack an error of judgment in dealing with this matter, that you are just rushing things through, you cannot see the difficulties that we are going to face, to recommend to the president to appoint a judge who comes with 3 versions, which change from time to time? Will I be unfair to argue that way? Maybe you can just help me.
With respect, my respectful and humble submission, Honorable Commissioner, is that that would be very unfair. Because I considered the last time that I provided the information to the colleagues. The colleagues are confirming today.
Mr. Kholong, it's late in the evening. You're an intelligent man, and certainly no one around this table is stupid. I think we should just put a stop to this. You have given 3 different versions, and each time each one of these versions was put to you, you became evasive and you became belligerent. That's the word that came to me as JP Tlalese was questioning you on Friday, and it was the same. The impression got even stronger when Commissioner Pillay questioned you about this. You were evasive. I mean, you were asked a simple question. Let me just go to the relevant page, the first version. JP Tlalese says, I noticed that these 2 nomination letters are identical. Have you noticed that? And you say yes. Who drafted them? And you say I was involved. I was aware of the nomination. Then he says, I don't understand who drafted the letters. A simple question, and goes to pages you avoiding to answer that simple question. And then later I would say you provided information for quality control, and today you are telling us that you gave them a template. Why are you doing this to yourself and to us?
I'll take the submission no further, Chief Justice.
I'm just concerned that the public out there and the professional bodies are watching what is happening. This does not reflect well on you. Thank you.
Thank you, JP. Commissioner Trollip?
I'm covered, thanks, Chief Justice.
Any more questions for the candidate colleagues? All right. Thank you very much, Mr. Kholong. You're excused.
Thank you, Chief.